The election fraud case against Donald Trump is dead, according to Syracuse law professor Greg Germain's latest takeaway, after the former president was indicted yet again. Now, for context, prosecutor Jack Smith filed new paperwork to re-indict Trump on 4 felony charges relating to his effort to subvert the 2020 presidential election. Now, given the Supreme Court's July ruling that presidents, current and former, have sweeping immunity, Smith's latest action takes that order into consideration.
But will it work? Germain says no, telling Newsweek recently, quote, "While the lower courts may try to interpret their way around the Supreme Court's decision, ultimately, I think the election interference case is dead before the Supreme Court." Here to discuss further is Gregory Germain, an attorney at law and professor at Syracuse in New York. Welcome, Gregory.
Thank you. Good to be here.
So help us understand why you believe this case is dead at the Supreme Court.
Well, I mean, it's not at the Supreme Court right now. You know, it's back in the trial court, and then it'll go to the D.C. Circuit, both of which ruled in favor of the government. So I think they're going to try very hard to interpret around the Supreme Court's decision. But basically, they said intent doesn't matter. And if intent doesn't matter, the only thing that matters is whether it's plausibly related to his actions as president. I think it's just going to be very, very hard to meet that kind of a test. Now, I'm very critical of the test. I think it was very overbroad and unnecessary. But that's what the Supreme Court said. And so it's just going to be very hard to get around that ruling in connection with an activity that had some relation to his office.
I think a lot of the frustration with the ruling is, of course, that it did not very carefully or at all, to my recollection, define what is an official act of the presidency. It kind of said that, yeah, there's definitely some acts that would be official acts, and there are certainly some that would not be official acts. And we leave it to you to figure it out and bring a case before us that narrowly hinges on that matter, and then maybe we'll describe them more specifically. How does that relate to which charges Jack Smith decided to keep and which he's not proceeding with?
Well, he dropped everything that the Supreme Court kind of directly said you can't charge the president with. And so a charge that he conspired with his advisors, the Supreme Court said, he's allowed to conspire with his advisors. And so he dropped those things and he labeled other activities as private. And so if he met with advisors who weren't government employees, they said he met with private advisors who weren't government employees. So he tried to do his best to identify the things as private activities. But the problem is how broad the ruling is. And I thought the ruling was very wrong in not recognizing that the important distinction between private and public rulings is the president's motive. If he has a corrupt and improper motive, then it should be private activity. If he's doing something that he thinks is best for the country, then it's a government activity. But by eliminating that distinction, I think the court made it virtually impossible when you've got something that is broadly related to being president, involving an election, to successfully argue that it's private activity. On the other hand, the other case, which is which was dismissed in Florida based on the prosecutor's appointment, involving the documents case, I think that's going to clearly be private activity because it was after he was in office and had nothing to do with his governmental function. But I think the election interference case is going to be very hard to, dance around the limits that the Supreme Court put on the case.
Can you help us understand that distinction you just made between was it official acts or not, whether or not the best interest of the country was at heart when the decision was put forth versus not? And if not, then it was a private decision. Can you help us understand that?
Yeah, what I said is that I thought motive is the key distinction. So was Trump motivated by what he believed was in the best interest of the country, or was he motivated to do something against the best interest of the country that was in his personal interest? And the Supreme Court specifically said motive plays no part in determining whether it's a governmental or private activity. And I thought that was just clearly wrong. And I think it was wrong from a historical point of view, and I think it's wrong from a policy point of view. So historically, the drafters of the Constitution were very concerned about corruption. They put a clause in the contract saying you can't take any gifts, and so the idea that someone with corrupt motives would be able to treat it as a get immunity, I think is completely wrong. And so if the president, for example, sold pardons for money, $100,000, I'll give you a pardon. Something as corrupt as that. I don't think any of the drafters of the Constitution would have said you're immune from prosecution for that. But the Supreme Court said, yes, you're immune from that. If a president for corrupt motives tried to get the SEAL Team 6 to kill a political opponent, that would be his motive would be the problem. And the Supreme Court said, no, we have to hope that the military wouldn't go along with his order, but that would be a governmental function. And so, I mean, I think the ruling was so broad and ignored the most important factor that I just don't see a way around it.
Well, obviously the dissent referenced that specific scenario, the president ordering targeting an assassination or something of a rival. The majority opinion did not specify that type of action would count as an official act at all, right? I mean, that could if that sort of thing happened, do we have any reason to expect the majority wouldn't say, well, that does in fact fall outside the obvious official duties because there isn't a right or a official reason to carry out an action like that?
I think John Roberts' decision did say that hypothetical would be an official act. That's the problem with the opinion. You're right, of course, that it was a very closely divided Supreme Court, and a change in the Supreme Court might result in reconsideration of this decision. But as it stands now, I just don't see a way around it.
So do you think Trump's team's decision to delay this case as much as possible, seemingly, is so that they can construct an argument? Do you see them cooking something up in defense of Trump, or do you see this more as their intention to delay beyond the election so the election can happen, potentially Trump can be in office, and the hearing will never happen? What do you make of Trump's legal team's position now?
I don't think there's much doubt that this case is going to get delayed until after the election. And certainly then there will be appeals from it. So, nothing's going to happen before the election that's going to decide this case. We're only 2 months away from the election. So they've very successfully delayed all of the federal cases, the cases that were the strongest cases against Trump. And so I think we won't get any kind of real conclusion until after the election. Now, the real question is what happens after the election, and I think if Trump's elected, the cases are gonna die because he's going to cause them to be terminated either by pardoning himself, which the court has suggested a self-pardon is okay because motive doesn't matter and he has absolute pardon power, or by appointing people to the Justice Department who will dismiss the case. So very much, the case only has a chance of surviving if he isn't elected.
Professor, thank you so much for joining us to discuss. We appreciate it.
You're welcome. Thank you.